Okay, we're going to start in just 1 second. People will be coming probably in and out during the webinar, but it's not going to affect the presentation in any way. We're going to start showing the screen in a second. I guess message me if you have any problems seeing it or hearing me, okay? Okay, welcome to tonight's webinar, 10 Important Tips When Drafting Your Estate Plan. The webinar is intended today to be approximately 45 minutes. I used to do an hour webinar, but some people suggest that might just be a little too much for people's evenings. So I reduced the format a little bit. You'll notice this is a one-way communication, so you hopefully can hear me, but I won't be able to hear you if you speak. There is a panel on your right. You'll see it's a GoToWebinar control panel. There's a way down towards the bottom right where you can post questions. I will most likely not be addressing them during the webinar, but I will be addressing questions afterwards, and I'm going to take as much time as I need to address them, so that even if we do run a little overtime, I will stay online to address everybody's questions. I would recommend that you post a question when it comes to you instead of waiting, so that it'll be up there and ready when I get to the end of the webinar, in case you should forget, or maybe issues get a little confused by the time we complete it. Like I said, I will be spending as much time as necessary to finish your questions. The webinar, like I said, may go a little less than 45 minutes. It could go a little above 45 minutes. I'm going to do my best to keep it in there, but I will stay as long as possible, or as long as necessary to finish all your questions afterwards. I am recording this webinar. I will send you a copy afterwards so that you get to review it at your leisure. And feel free to email me with any issues that maybe arise once you get it that we didn't get to discuss today. Lastly, you will be receiving, I don't know if it's immediately following the webinar or maybe tomorrow, you'll get a brief survey that I'd really appreciate if you take a few minutes to complete. It is very helpful for me to know a little bit about the success of the webinar, how you found out about it, and just helps me overall plan for future ones. So I'd appreciate, like I said, just taking a few minutes to address that. Okay, for those that have not met me, this is me. My name is Brad Micklin. I am the managing member of the Micklin Law Group. I've been a practicing attorney for more than 17 years now. I'm a member of the New Jersey and Pennsylvania State Bar Associations, and licensed to appear in both state and federal courts. I started my legal career as a judicial law clerk for the Honorable Eugene Austin in Bergen County, doing special civil litigation. The experience was very helpful. It was a high volume pro se type of court, meaning people represented themselves, and it gave me a great deal of exposure into what it is like for individuals to be handling litigation. I also got to see a lot of what happens behind closed doors of the chambers, what happens when judges get your papers and how they handle it. So it really gave me a good understanding of how the system works before I actually had to enter it and start practicing that way. From there, I went to do complex commercial litigation for several years with David Kessler Associates in Clifton. Again, great experience in that what we do now is a different form of complex civil litigation. So the experience was good. Didn't really like commercial litigation because I like to deal with people and not companies. I think it's more personal, and I think the purpose of law is to help people. So I moved on from there, and in 2001, I opened my practice as a solo practitioner, which means I did a little bit of everything at the beginning, and then I slowly realized that you can't do everything well, so I started to concentrate my practice. Now, my practice has always been concentrated, as well as the Micklin Law Group's current practice is concentrated in divorce, family law, and estate planning issues and litigation. The Micklin Law Group has 2 additional associates, Rachel Isaacs, who is our senior associate, and Richard Muglia, who is our newest associate. We have several support staff members. Stephanie is our current paralegal. Carmen is our client service manager. And we will, from time to time, have various administrative staff members to also assist clients. The purpose of our firm is to be sort of a boutique firm. It's large enough to handle complex cases, but small enough where we know who you are when you call. Okay, so let's move right into it. 10 important tips while drafting a will. The interesting thing about this webinar is when I first set out to do it and started planning the materials, I was concerned that I might have trouble filling 45 minutes of time. And then what I realized was, as I noted each specific tip that I thought was helpful for people to be aware of, I discovered that almost every individual tip could probably take a 45-minute seminar. And the complexity of the issues so far overreaching that it was so voluminous to actually narrow down. So what I decided to do was to first give you a snapshot of the 10 tips that I think are most important for you to realize. Go through them with a little detail so that I make sure that you have them, regardless of our time constraints. And then afterwards, go through in greater detail some of the more complex issues. All right, so let's jump into it. First, number one, start planning now. Everybody that I speak to, almost everybody, either does not have or has not updated their estate plan. Everybody from company employees to attorneys that I meet don't have them. I bet the majority of people here today don't have them. People think that planning your estate is planning for your death, and it's not. As we'll get into a little later, there are other documents necessary to an estate plan, not just your will. In my opinion, the will is probably the least important of an estate plan. The other documents you're planning for your life, for people that will have to make decisions for you if you become unable to do so. So you really need to put aside that mindset and realize the significance of getting this done and getting it in place quickly. Second, inventory of your assets. Most people don't fully realize what is an asset, what assets that they hold, and how those are valued and changed. So the first thing you really need to do is to sit down and look at what you have, what you own, and also look at what's called a contingent asset, meaning something in the future. You want to decide, are you going to likely inherit an estate? Is there litigation that you're involved, both on the plaintiff side or defense? Are you likely to lose an asset in the near future? So you really need to take an inventory of what you're sitting with right now. Now, the third tip, review and update assets. It may sound like the same thing as inventory, but it's really different. It's unique, and it can be a time-consuming but very important process. You need to do a couple things. Primarily, and most importantly, you need to figure out what the basis is, or the original purchase price or acquisition price, and the current value. Those will often be very drastically different, but knowing the two numbers will help you significantly planning your estate, as well as any kind of alternate options that you have. I think you also need to review life changes and how they may change in the upcoming years. Is there a retirement in your future? Are you looking to switch jobs? Are you buying or selling a house? These are all going to significantly change the value of the assets that you're currently holding. So it's wise if you could try to build in some planning before you actually do your estate plan. Next, 4, consult with professionals. Now, this is going to depend somewhat on the assets that you have, the value of the assets that you have. At a minimal, you need to speak with a lawyer. Even if you're going to use one of those forms on the internet, which I do not recommend at all. To some extent, I think you're better off writing it yourself than using those forms. And I also don't recommend that you write it yourself. Just making a point. But definitely speak with an attorney. Most attorneys, including myself, will give a free consultation or waive the consultation fees. I do charge for my consults, but I do waive them if you have attended a webinar and you want to have a consultation regarding the topic. So if you just advise my staff when you call, they will waive the consultation fee as a courtesy. I think it's also good to speak with an accountant. That way you can figure out the true value of your assets when you're looking at the basis of something like your house, for instance. You may think you know the basis because you know what you bought it for, but there are things like capital improvements that you may be unaware of, capital gains and losses, carry forwards, things like that, that really only an accountant can properly advise you. So while you're doing steps 2 and 3, inventorying and reviewing your assets, you really will need the help of an accountant to ensure that you're getting the proper information. You also want to meet, I would think, with a financial advisor. One, to make sure, again, that you're valuing and inventorying your assets correctly, but also to get some planning for your future. In order to know what assets you're going to have in your future, whether it's a short-term year or two or 10-year plan for retirement, financial advisor will help you not only figure out where you're going, but will help you with other alternative methods of planning, which we will discuss shortly, which is number 5, actually. Consider alternate plans. For reasons I'll discuss later into the seminar, you want to try to avoid having your assets pass in a will. And I know that's kind of ironic that I'm sitting here telling you need to do a will, but then telling you don't want your property to pass through a will, but it'll make sense later. Even if all of your property passes outside of a will, you still want to have a will. Things change and you want to have that backup. But there are a lot of options like gifting, trust instruments, converting property into joint property, bank accounts, real estate, so that it passes automatically. This, of all 10 points, is probably the most important because it will do you the most benefit both now and in your estate planning, to know your options and to consider utilizing as many as possible. Number 6, you want to have a comprehensive estate plan, meaning you don't just want a will. You want a will, but you also want a power of attorney, a living will, and a medical directive. Those documents have a little bit of complexity to them. There are more than one type that you can. There is more than one type of those documents. I'm not going to go into at length, but a full estate plan should have at least those 3 components: a will, a power of attorney, and a living will or medical directive. Next, 7, advise your beneficiaries and your fiduciaries. Beneficiaries will be the people who receive your property under your will. Fiduciaries will be the people that are in charge of helping either manage your estate or your assets after your passing. Whether or not you tell beneficiaries, that's really a personal choice. You may want to mention if they are in your plan. It eliminates some issues that come up, in your passing and litigation. But more importantly, fiduciaries, people that are going to be handling your estate, people that will be handling your money or possibly custody of your children. These are big responsibilities. You want to make sure that you're naming people that are able to and willing to take them. Because if you name people who aren't willing to do so, then there's a lapse in that and litigation ensues to fill it. And it's just a mess that you hope to be able to avoid. Number 8, specify your reasons for dispositions. Now, this can be inside the will documents themselves, or you can do it just by having notes both with your documents or with the lawyer who drafts them. But you want to specify why you're giving the people in your will what you are giving them, especially if it's going to be considered what's called an unnatural disposition. If you're eliminating one child or giving more to another child or giving to charities, it's very easy to challenge a will currently. And until that changes, I often recommend people do as much as they can to show why they did what they did so that it eliminates those challenges. Number 9, provide copies of important documents. Now, this also will depend on what your estate consists of, but you want to have at least copies of the deed to your house. You want to have copies of insurance policies, even though they don't actually pass through your will, but insurance policies are very important for your beneficiaries to know. Appraisals of any property. If you're following my advice in number 2 and 3, you'll have appraisals for property or evaluations that you want to place with this. And you want any documents evidencing who may have these documents. If you, for instance, give all of your documents to the person you name as your executor to hold for safekeeping, you want to have a document in your house or safe deposit box or whatever saying where these documents are. Some people don't want to keep documents in their house, so they keep them in a safe deposit box. But leave a note with your personal effects that you have a safe deposit box, or that these documents can be found in a safe deposit box. And lastly, notify your fiduciaries of the location of these documents. Now, there's a lot of different ways to do this. Like, for instance, when I do an estate plan, I give at least 2 originals, one that you keep and one that you send to your executor, because if you don't have an original, copies are hard to admit, or they're hard to use in court. So you want to avoid having to do that. So if you give an executor a copy and you have a copy, if God forbid, you perish in a house fire, there's another copy of the will. Let's say unfortunate that your executor passes in a house fire, then you have the original copy of the will in your house. So at least having 2 is good. So you can mail it. You may want to, again, put them in a safe deposit box or leave them in your house, but let the fiduciaries, your executor, for instance, know where you have these documents so that they are able to go and get them. And the same for power of attorney and a medical directive. These are important documents. They're powerful documents. Some people don't feel comfortable giving them to the people who have the power until they need it, so you want them to know where to go. Should you become unable to give it to them, they know how to access these documents and use them for your benefit. Gifting exemption. So here we're going to start turning into some of the more complex issues. I'm not going to go deeply into them because they are very, very complicated. Like I said, we could sit for an hour on each topic and never fully cover them. So gifting and exemptions. These are very, very complex issues. They are important that you do your best to learn them or to understand them. I've unfortunately found that many people don't understand them, even people who are charged with knowing or should be charged with knowing, like accountants and some lawyers. So you really want to make sure that you're dealing with people who understand these. They are most important, really only important for high net worth clients. There's a federal exemption of $5 million and a New Jersey exemption of $675,000. This means that your estate is not taxed unless you have assets greater than these 2 dollar amounts. So the majority of people don't worry about a federal exemption. But many people will have to deal with a New Jersey exemption. Aside from the value of their assets, you will also have the contingent assets that I mentioned earlier, like a life insurance or an inheritance that can quickly take your estate over the 675 limit, sometimes even over the $5 million limit, because a lot of people have millions of dollars of life insurance coverage or a personal injury action. So it's important to keep these in mind when you're planning. If you follow the tips and you're planning for future contingencies, you can build in ways to protect through the alternate means that I suggest to protect yourself from being taxed. Taxes are a very significant burden to an estate. They can be in many ways almost a third, sometimes up to a half of an estate if you don't plan properly. So you definitely want to avoid as much of this as you can. Again, if you currently have assets over $675,000, then you do have some issues, and you do want to get some help with your estate planning. There's a note about inter vivos gifting lifetime gifts. New Jersey doesn't have a gift tax as far as I know right now. Gifting is a complicated issue. You'll hear a lot of things about like a 3-year look back period and giving gifts each year for now at $14,400. A lot of people aren't really clear about the gifting idea and how things work. The purpose of these annual gifting and your lifetime exemptions isn't necessarily because they're going to pay tax on the gift, but it's more of a tracking device for the Internal Revenue Service. So you're allowed to gift over $5 million in the course of your lifetime. The reason why you can gift $14,400 per person per year without filing a gift tax is because they know you can't gift that much individually. And because it puts money into the flow, the IRS isn't so concerned about those small gifts. But over that amount, you will file a gift tax return so that they can add up over the course of your lifetime, whether or not you in fact gave out more than $5 million. And that's when there's going to be an effect to your estate. It actually starts to go into your federal exemption amount. So when it comes to gifting, you don't need to be concerned about gift tax, paying a gift tax. People are often concerned that the person they're giving a gift to will pay a tax. It's not going to happen. But if you're giving more than $14,400 to that person per year, there's going to be a gift tax return that needs to be filed. So planning your estate, try to work in these numbers. If you're going to gift more than that, or you want to plan to give more than that in your future, speak to an accountant and again to a financial advisor so that you can make sure that you properly document it and that you're doing it so that nobody, including your estate, gets a burden from it. Okay, testamentary and living trusts, probably one of the most important vehicles to simplify an estate, to reduce taxes, and to overall benefit your beneficiaries with your property. When they become effective depends on the type. As I listed at the top, there's two main types. There's testamentary and there's living. Testamentary means that it doesn't really exist except for by language in your will. And your will says, when I die, I want to create a trust and I want property to go into this trust. A living will is effective when the document is created and signed. I tell people it's sort of analogous to a corporation, sort of something that doesn't really exist, but it exists. It's a legal creation. When you create and sign a living trust, it exists like a company. It can own assets and transfer assets. So although it's effective when it's signed and registered with the IRS for a tax ID, not really effective until you transfer assets into it. Greatest mistake many people make when they plan and create trusts is that they create it with their lawyer and they get great fancy documents, but then they don't remember to transfer anything into it, and it's meaningless planning when somebody later passes. So it's important to understand how trusts work and to make sure that what you intend to go in there actually does get transferred in there. Second, it protects and safeguards assets. It will greatly reduce, if not eliminate, estate tax. In many chances, it can also be used to eliminate income tax. So it's a powerful asset, even it's a powerful instrument even for current planning. Not before you even need to plan your estate. It can help many people with assets now. And the biggest benefit, the way it protects and safeguards your assets, is that assets that you put in trust for another person transfer almost immediately to that person at your passing, which is a tremendous benefit for them, because the probate process, which I'll talk about in a second, can be a very long, drawn out, slow process. And the whole time beneficiaries are sitting waiting to get assets. And who knows what happens to your assets throughout this long process. Sometimes, they're greatly affected, and then what you intended for your beneficiaries to receive, they don't, or they receive less. Income tax as a separate entity. As most of you probably know, there are different income tax levels for different amounts of income. They are taxed differently. There are different tax brackets for the income that goes into a trust, as well as whether or not there's disbursements outside of the trust or they build inside of the trust that will greatly affect whether or not they're beneficial to you from a tax standpoint. But usually, especially in higher income and asset cases, trust planning is usually very, very important and very helpful. Now, there are many other benefits to a trust instrument that I can't really go into at length in this seminar, but I would highly recommend that everybody find out a little bit about trusts, even if you don't think that you have a lot of money to go into it. For instance, there is a life insurance trust, which is a very common type of trust planning that is created, even though it doesn't really have any assets. It will own the life insurance policy that you have and allow the death benefit to pass through without going into your estate, goes into trust for the beneficiary, and then you have greater control over how that money is used. You may have a $5 million life insurance policy for your spouse or for a child or a grown child even, and you don't necessarily want that person to come in the $5 million in one day because of responsibility issues and tax issues. You may want to have greater control over their receipt of it, but insurance policies are paid directly and immediately. So a trust, an insurance living trust, a living insurance trust is a very good vehicle for those reasons, as well as many others, like I said, that we can't really go into at length today. So let's talk a little bit about probate versus non-probate property. It's a very common misconception, or there are many misconceptions about probate. Some people often think that certain things don't go through probate and that makes a big difference. In some cases it does and it doesn't. So probate is the legal process through which your estate will pass. Whatever is considered probate property gets added in, we total up the estate, and that's how it's determined to be taxed and then distributed to the intended beneficiaries. It's a very formal, very long process. Non-probate is property that passes outside of your estate. Now, the important thing here is that to some extent it's still added to your gross estate. Even property like insurance that is non-probate property. Non-probate property is property that passes outside of your estate. Things like insurance proceeds, retirement accounts, joint bank accounts, joint real estate holdings, anything that has either a named beneficiary or a co-owner passes outside of your estate. It's considered non-probate property, passes immediately to the co-owner. But it is added to the gross estate for tax purposes. So if you have a $10 million life insurance policy payable to a child or to your aunt, a different level beneficiary, that's non-probate property and it will pass outside of your estate, but it is counted in your estate for estate tax purposes and can create a very significant mess because the person who's receiving the insurance, the beneficiary, isn't part of the estate, but the estate's getting taxed. So your beneficiaries the beneficiaries of your will may have a tax burden on property that they didn't get. But going back to the benefits of non-probate, your assets are received sooner. Like I said, it passes almost immediately. Legally, it passes immediately, but there's always paperwork and new documents that have to be drafted or instruments that have to be conveyed. But the legal aspect of it is that it transfers immediately without the very formal process of probate. It's informal, and the non-probate properties are the alternate planning that I mentioned in the very beginning. Trust planning, gifting, and creating joint property. So all those cause the property that you utilize in that alternate method to pass outside of probate. So why is it important to eliminate probate? And that would be the costs. Significant amounts of money can be consumed through even an ordinary probate, let alone a contested one. There are first executor and administrator fees. Executor is the person that you name to handle your estate when you pass. Administrator is a person that's appointed if you don't have a will to serve as the executor of your estate. The executor or administrator gets a commission on your gross estate. I believe it can be anywhere from like 3 to 6%. Now some waive their fees because a lot of times executors are also beneficiaries or close family members, but they have the right to take that. It's a significant fee or commission. If there's income received after your decedent's death, rental incomes, capital gain, they also get a portion of that income. Sometimes there's Social Security payments, lawsuits that are settled. And then there's attorney's fees because most executors will also have an attorney. Sometimes your executor will be an attorney and they serve as a dual capacity. Attorney's fees, I usually estimate that can be about 5%. So when you take executor commissions and attorney's fees, you're looking at anywhere from 6 to 10% of your gross estate just in the cost, and that's for a simple, uncontested, relatively simple probate matter. Again, as I said, your attorney can also be a personal representative, but they are entitled to both commissions and legal fees. So sometimes you think that you're maybe saving money by naming an attorney as your executor. What you want to do is specify in that document and with that person that you're naming, going back to my earlier advice about notifying your fiduciaries, if you named an attorney to serve an executor, you may want to determine and specify that it is to only be one or the other. Either they get their commissions or they get their fees. That you do not intend for them to take both. And you may want to get their agreement to that before they actually get named in a document. Now, there's certain other issues that come up with that too, because if you're going to name an attorney who's drafting the document, they have to advise you of the conflict that can appear there, or the appearance of a conflict. The beneficiaries may later be unhappy, but your attorney will understand that. So just remember, there's an issue to discuss with your lawyer if you're planning to name a lawyer as your executor. Okay, so let's look at additional costs too, aside from what I just mentioned. There are other times and other issues that arise in probate that cause your costs to escalate. One is tax professionals. Some cases have very complex tax issues. I represented an estate one time where the decedent owned 10 pieces of very valuable real estate in Hoboken, worth about $10 million in total. She unfortunately had no estate plan. So, and this was years ago when the exemption amount was a lot lower. I think it was about $1 million as opposed to the $5 million now. So she had $9 million of taxable income. The estate paid $5 million in taxes because of her failure to plan properly. And the cost to manage that, because you needed people to handle the real estate, not only the sale of it, but to manage the property management, collect the rents, pay the bills. We had to bring in professionals to run the properties at a very significant cost to the estate. And there's tax returns. You're going to have the decedent's last year's income taxes filed, as well as an income tax return for the estate, both possibly federal and possibly, most likely federal, possibly state. So you're going to most likely need an accountant to prepare these tax returns. And again, even if you named an accountant as your executor, they're still going to be entitled to their executor commissions as well as their professional fees for the completion of these returns. Next, on the bottom, and the most important thing to consider is a will contest. And for those that are interested, I have some information on my blog that I can give you about will contests, how to plan your estate to hopefully avoid them, as well as if you're involved in them, some ways to plan and litigate to give you a greater chance of defeating the contest. But for today's purposes, will contest, that's when somebody claims that either the person who left the decedent was either unduly influenced or lacked the ability or capacity to make the will when they did make the will, and that there's usually an unnatural disposition. So if you have anything that's out of the ordinary, like one child getting more than another or one family member being excluded, it's ripe for a will contest. And they're very, very common. And the reason and the burden usually comes out to be the attorney's fees, quite honestly, because the way the current law is if you file a will contest with a good faith basis, meaning you believe you have a good reason to do it, whether you actually have proof or not, whether or not you're successful or not, if you had a good faith belief, then the estate may be required to pay the legal fees of the person who challenged. So they have very little to lose if you have a will where you have an unnatural disposition. The person that you're cutting out has very little to lose by filing a will contest because they may not incur legal fees. The beneficiaries in the estate suffer the most. So you really want to plan, and this goes to my tip earlier about notifying fiduciaries and beneficiaries as well as documenting the intention for it. And you can do that in many, many ways. You can do it in the document or you can do it out of the document. But communicating your wishes clearly are ways to help eliminate will contests. The next best way to eliminate will contests, as I keep indicating, is through your alternate methods of planning, gifting, trust instruments, joint property, joint tenancies. Can't stress enough the value of proper planning because, unfortunately, a lot of people believe, well, that would never happen in my family. But it does. And a lot of times there's family you're not really considering. You may have young children now, but they may be married and have spouses at the time of your passing. And those spouses will have an interest. And they often will promote a will contest where maybe the siblings themselves would not have. Simply put, it can get ugly, and you really want to plan for it to avoid that. The family's going to be going through enough dealing with the losses and the legal processes that you don't want them to be fighting amongst themselves. So gifting, trust, and joint tenancies help eliminate a lot of that, as well as documenting the intention for any unnatural disposition. Now, estate planning and children, very, very important. Obviously, there's two main aspects when it comes to estate planning. When you have children, one, you want to plan who is going to care for the children and who's going to care for the finances of the children. These may be different people, and there's a lot to consider. First, before I start going through what we've put up there, things that you should be considering are the capabilities of these individuals. On the one hand, sometimes you'll have younger family members that you want to entrust with the care of the children because they'll have more energy. They may have younger children also, but they may not be as financially savvy as your parents or your grandparents or your uncles. So you may want to list one person or family to care for the children, but an older separate member to handle their finances. Now, the flip side of this concern is the people who are caring for the children are the ones who really need access to the money because they're the ones that you're entrusting to care. You want them to be able to provide the best possible life for the children with the least amount of difficulty. So if they have to go jumping through hoops to get money from the children's trust fund, it's going to complicate their ability to care for your children and may complicate their desire to do so. As much as they may love you or your children, when it comes to family money, again, it can get a little ugly. So you need to look at these and kind of balance between what is the life that you're looking to create, which is the greater concern. Can it be the same person handling the custody of your children as well as the finances? Does it need to be somebody separate? And if it's going to be somebody separate, will they get along with one another? Now, also going here up to the notes, care of the children. A lot of people will want to, especially in like a divorce or unmarried couples, they may not want the other parent necessarily to have custody of their children. For whatever reason, they may feel that they're not as capable or qualified, or that the best interest of their children would be served by somebody else having custody. Now, the surviving parent has a constitutional presumption of custody. The law basically says they have a constitutional right to a relationship with their children. However, New Jersey's law says, and probably most states, that New Jersey has an interest in protecting its children, and that all issues of custody are guided by what is in the best interest of the children. So it's not a 100% that the other parent, natural parent, gets custody, but it's a 99%. But the court can determine if it's in the child's best interest to be with somebody else. So if this is going to be an issue, I usually recommend that you put it in your will. Who is getting custody and the reasons why. You may even want to try to document it. It's a little out of the ordinary, but you may want to put some documentation to evidence the reasons why your child or children are better with somebody other than the natural parent. It will serve as guidance to the court. The court will look at your document, especially if you're the custodial parent, because you were the one who was entrusted with the day-to-day decisions. And this is a significant decision, so they will be guided by it. And then care of the children's finances, the court's bound by the estate plan if you use a trust. Meaning, and most of the time, if you have minor children, you want money to go into trust because otherwise it goes to them directly with no supervision. And then the court has to handle it. And you really don't want that. That's why you want to have what we referred to earlier as a testamentary trust, so that you can designate who handles the money and how the money is spent, what needs and expenses are covered when they get monies and bulk distributions, if at all, and at what age they would get it. So you have control over how your child's money is going to be used and if and when they actually get it for themselves. Okay, so coming to the end, we still have a few minutes left, which is good. In a second, I'm going to turn off the screen showing and then start answering the questions. I'm not really sure what appears when I do that. Hopefully you'll just get like the sort of like the welcome screen. But when the screen stops showing, I will get to see the questions. I'll give it a minute or two to get questions up. I believe, unfortunately though, I've never sat on this other side of this, but I'm advised that your questions are not viewed or seen by the other participants, so only I get to see them. So you don't need to worry about um, anonymity when you put these questions up. So give me a second. I'm going to shut off the screen. I'm going to then start addressing some questions. Okay, give me like 10 seconds. Start typing up your questions, and I'll start addressing them right away.